judiciary again is the most respected and again trusted branch of the government, right? If such kind of incident happen, what mechanism do we have? Do we have anything? Does the constitution says anything regarding this particular issue?
If misconduct is very serious, then Chief Justice of India will advise that judge to resign or to take retirement. If judge will not resign or will refuse to resign, then Chief Justice of India may direct Chief Justice of the concerned state to deprive that judge from all judicial responsibilities.
As we say in our democracy, Caesar's wife should always be above suspicion. For that, what is required? Transparency and accountability. Unfortunately, in this in-house mechanism, there is neither transparency nor accountability, because everything is done in a highly confidential manner.
But the question remains, should the mechanism be formal and codified, formal and statutory, or should it remain informal and ad hoc, which then leads to speculation in the public domain about the weakness in the accountability mechanisms?
That what all mechanisms can again be suggested apart from what we have in our country as of now?
Only external mechanism will not help, but internal mechanism also should be developed to make our accountability system more effective, and that will of course increase and enhance the public trust in judiciary, and that will be good for the Indian constitution and constitutionalism.
Hello everyone, welcome to the Perspective series of Vision IS. Recently, there has been a controversial issue regarding Justice Yashwant Verma of Delhi High Court. This issue has sparked a debate regarding a topic of judicial accountability and its credibility. And it is of very paramount importance to know what exactly it is. So today in this conversation, we are joined by the esteemed faculties of Vision IS, and we will be discussing in depth around that particular topic, what exactly it is, what are the nuances regarding that particular topic, right? So let's start the discussion. Hello everyone, sir. So Anjani Sir, I'd like to ask you and again give you your opinion that what exactly was the issue regarding the Delhi High Court judge?
Paritosh and everyone in the audience, insofar as we are aware, and these are facts in the public domain, on 14th of March, a fire was reported at the residence of Justice Yashwant Verma of the Delhi High Court. And during the fire control operations, it was reported that large wad of cash was recovered from the place where the fire had taken place. And this instance then was escalated, including to the highest echelons of the judiciary. The CJI then took certain steps in this matter, including constituting an in-house inquiry with 2 Chief Justices of High Court and another Justice of High Court being a part of it. Justice Yashwant Verma has been transferred to the Allahabad High Court, and the matter continues to be under inquiry, a matter of inquiry. And so this is something that then brings attention again to the functioning of the judiciary in India, where the independence of judiciary is certainly accepted by everyone to be a foundational value within the constitution. It is the accountability aspect, the transparency aspect of it, which has attracted attention once again, and the debate has once again opened up.
So again very beautifully explained. Now that we know that judiciary again is the most respected and again trusted branch of the government, right? So if such kind of incident happen, what mechanism do we have? Do we have anything? Does the constitution says anything regarding this particular issue? So Ashok Sir, I would like to take your opinion that what does the constitution says, or what mechanism do we have if such kind of incident happen in the judicial branch of government?
Paritosh, actually really we have a very bad situation, and we are suffering from deep trouble. Indian judiciary, that is custodian of constitution and rule of law, and at the same time is considered as a last bastion of hope for the people of this country, is suffering from a very serious crisis, and that crisis is actually a crisis of credibility. We don't have any kind of effective mechanism, but Supreme Court in 1997 had taken decision to develop one in-house inquiry mechanism, and that mechanism we had developed only after one case, that was C. Ravichandran Iyer versus Justice A. M. Bhattacharya, 1995. And that case actually exposed the absence of effective internal mechanism to deal with judicial misconduct that was actually not related to article number 124(4) and 218. So for that we had constituted. That in-house inquiry mechanism is nothing but a bridge between bad conduct and misconduct or misbehavior. We all know that misbehavior is mentioned in constitution, but bad conduct is not mentioned. So for that we developed that mechanism. And another development came in 1999 when we adopted procedural aspects to deal with complaint against judges. 1997, 5-member committee had submitted report, and on the basis of that report, procedural framework we had adopted. That procedural reform, procedural aspects is divided into number of stages. Take example, when complaint is lodged before Chief Justice of India or Chief Justice High Court, or even President of India also can receive the complaint. So most of the time when Chief Justice High Court or President of India receive complaint, they used to forward it to Chief Justice of India. And the Chief Justice of India most of the time direct Chief Justice of concerned High Court to conduct a preliminary inquiry. On the basis of that inquiry, Chief Justice of India decide to constitute a committee. And Paritosh, that committee also will find different categories. If Supreme Court judge is involved in the case, then 3-member committee will be constituted, and all 3 members will be from Supreme Court. If Chief Justice High Court will be involved in the case, then committee will consist of 1 judge from Supreme Court and 2 Chief Justices from 2 different High Courts. And if 1 judge of High Court is involved, then committee will consist of 2 Chief Justices of different High Courts and 1 judge from another High Court. So this time Punjab and Haryana High Court and Himachal Pradesh High Court Chief Justice are involved in are a member of the committee, and 1 another member from Karnataka. That committee is expected to conduct inquiry. On the basis of the finding, ultimately Chief Justice of India will take decision. If misconduct is minor, then Chief Justice most of the time warn the judge or advise the judge. But finding will always be kept secret, that will be a confidential matter. If misconduct is very serious, then Chief Justice of India will advise that judge to resign or to take retirement. If judge will not resign or will refuse to resign, then Chief Justice of India may direct Chief Justice of the concerned state to deprive that judge from all judicial responsibilities. And Chief Justice may inform the President of India and Prime Minister also to take initiatives as per the demand of Article 124(4) and 218. So this kind of mechanism at present we have.
So now that Sir has explained very beautifully the procedural aspect of this particular process, I would like Pavan Sir to explain the audience what exactly are the advantages and disadvantages of the process which he is currently having.
So if you look at it, our constitutional makers, when they sat down to frame the constitution, their ultimate objective is how to ensure that the rule of law is implemented in both letter and spirit. They wanted to make sure that none of the organs of the state should become dictatorial in their functioning. They should be limited by their power. How to ensure that? That is when they made sure that these organs of the state are given only limited powers. They are given independence, but they are not given complete independence, sovereignty. In the case of judiciary, they wanted to make sure that judiciary should be able to rectify all its mistakes without any external interference from either legislature or executive. And that is when our Supreme Court had come out with this in-house mechanism. Now, what are the advantages of this in-house mechanism? First and foremost, there will not be any external interference in the functioning of judiciary. Because in this in-house mechanism, as Sir has pointed out, the committee consists of only judges from in a judiciary. there will not be members of parliament or anyone else from legislature or executive. Second advantage of this in-house mechanism is that it can ensure quick response. Why? Because this committee of judges, which has been constituted by our Chief Justice, is expected to come out with a report within a stipulated time period. Another advantage is that it will ensure confidentiality, because they are dealing with a very extra sensitive issue, which can have larger consequences, unanticipated also. These are all the advantages of this in-house mechanism. But what about the disadvantages? This is where the problem comes up. As we say in our democracy, Caesar's wife should always be above suspicion. For that, what is required? Transparency and accountability. Unfortunately, in this in-house mechanism, there is neither transparency nor accountability, because everything is done in a highly confidential manner. As Sir has mentioned, if the report finds that the judge has indulged in some kind of minor misbehavior, the findings will not be made public. A mistake is a mistake, whether it is minor or major. People have the right to know. Second, accountability. If you look at it, in the last past so many years, there are so many inquiries that were conducted, but where is the punishment here? At best, they were transferred, or some of them were asked to resign. That is not the punishment. If it is done by any ordinary person, what would have happened? FIR would have been filed, investigation would have been done, that person would have been punished strictly according to the law. In case of this in-house mechanism, there is no punishment. Another problem with this in-house mechanism is that this in-house mechanism does not have any statutory backing. That means it is not backed by any law passed by the parliament. It is according to the discretion of the judiciary. And the most important problem with this in-house mechanism is that what is the follow-up action? This follow-up action is again according to the discretion of the Chief Justice. This completely violates one of the most important principles of rule of law. What is it? Howsoever high you may be in terms of your status or position or power, the law is always above you. In this case, it is opposite. That is the problem.
Absolutely right, sir. Law is the supreme thing in the country. And one of the disadvantages which you talked about was of judicial accountability. So I'd like Sir to maybe tell what mechanism do we have in our country as far as judicial accountability is concerned in India?
So, Paritosh, first of all, the Constituent Assembly, when it was discussing the provisions regarding judiciary, the first and foremost value that it had in mind was judicial independence. So, judicial independence was the emphasis. Having said that, members like Alladi Krishna Swami Iyer had a clear view that this principle of independence is not to be converted or turned into a dogma. So, to start with, we have the provisions regarding the appointment of the judges, where the president, under the seal of the president, the judges are appointed. And then we have the provisions like under Article 124 about the removal of the judges, which provides for the impeachment process. Under Article 124 Clause 5, we have the Parliament, which was empowered to make a law. Parliament made a law which is called the Judges Inquiry Act 1968. And subsequently, what we see is the mechanisms have evolved through the actions of judiciary itself. There have been series of what are called the judges cases, right? Particularly the second and the third judges cases are instrumental in terms of appointment and the collegium system. And then subsequently, we have Supreme Court under justices, chief justices like G.S. Verma, where we have the restatement of values in judicial life in 1997. And as has been mentioned by Sir, the in-house inquiry mechanism was also constituted. There have been certain efforts to codify these or formalize these. For example, the Judicial Standards and Accountability Bill of 2010 wanted to create a system which formalized the measures for accountability. Unfortunately, that could not pass the muster. And then we have the NJAC, which was enacted again in 2014, which particularly focused on a streamlined process for the appointment of the judges, where the accusation on the judiciary is that nowhere in the world judges appoint judges. So NJAC tried to provide a solution for that, where there is a streamlined process for the appointment via a commission whose members were supposed to be the Chief Justice, 2 senior most judges of the Supreme Court, the Union Law Minister, and two eminent personalities who then again would be appointed on the recommendation of a committee constituting the Prime Minister, the Chief Justice of India, the Leader of Opposition. And there was also a provision that one of the member would come from scheduled caste, scheduled tribe, OBC, or women as marginalized communities. Now, the NJAC was an effort which targeted streamlining the appointment process. However, the Supreme Court struck it down in 2015 in what is called the four judges case, and the primary contention was the inclusion of a non-judicial member impinged upon the basic structure element of independence of judiciary. So, this mechanism has evolved. It's praiseworthy that Supreme Court itself has made an effort towards it, but the question remains, should the mechanism be formal and codified, formal and statutory, or should it remain informal and ad hoc, which then leads to speculation in the public domain about the weakness in the accountability mechanisms?
So now that we have discussed the in-house mechanism, its advantages, disadvantages, it should be very much important to know, is there any better mechanism apart from what we have in a country, or does any different country follow any different international mechanism which India should also adopt for? So again, Ashok Sir, I would like to take you or maybe ask you to discuss that what all mechanisms can again be suggested apart from what we have in our country as of now.
Actually, we are giving emphasis on accountability. And from my point of view, when we talk about accountability, we should go for a holistic approach to understand accountability. And accountability, I think, should be micro as well as macro. We have a different kind of ecological system. We have our own constitution. Our philosophy of the constitution different. And what I think, that we have socio-political economic environment also is different from other countries. So it will be better for us to come out with not only holistic approach, but we must have our own indigenous mechanism to deal with accountability in totality. And when I am talking about totality, that is micro as well as macro. When we try to see outside India, in UK we find one judicial conduct investigation office that was constituted in 2005 under Constitution Reform Act there. And that office is well structured, more transparent, and they used to public their finding before people of the country. Now when we see one another country is South Africa, there we find one Judicial Service Commission. That Judicial Service Commission I found more inclusive, more transparent, because representatives from different domains like judiciary, executive, legislative, even legal professionals also used to take part in that. And they conduct a public interview before people. They used to allow people to take part in the process. In that way, accountability they increase. But again, what I will say that we should not copy all those procedures. We may have one judicial accountability commission like institution, and that commission should be manned by or may be manned by retired judges, Chief Justice Supreme Court or Chief Justice High Court, along with legal professionals or eminent jurists of the country and eminent personalities from civil society. But it is very important and essential to maintain a balance between accountability and independence. So when we will go for balance between accountability and maintenance, I will give suggestion that whatsoever mechanism we will develop, that mechanism should address the restatement value of judicial life 1997 and Bangalore principle of judicial conduct 2002. So if those areas will be addressed properly, then micro and macro accountability will be ensured in India. Only external mechanism will not help, but internal mechanism also should be developed to make our accountability system more effective, and that will of course increase and enhance the public trust in judiciary, and that will be good for the Indian constitution and constitutionalism.
So taking the discussion along, I would like Pavan Sir to maybe address and now summarize the whole issue, that what exactly could be the way forward for this?
See, if you look at it, at present more than 57 million cases are pending with our judiciary at all levels. In the Supreme Court itself, more than 80,000 cases are pending. Around 60 lakh cases are pending with high courts. Rest of the cases are pending with lower courts. And as someone has said, it would take our judiciary almost 300 years to come out with judgments in all these cases, provided in the next 300 years no fresh cases are filed. So obviously efficiency, accountability and autonomy, all of them should be taken into consideration. Till now, what we are giving importance only to the autonomy of judiciary, without giving importance to either efficiency or accountability. So what can be the solution? First and foremost, we have to increase the strength of our judiciary, and there should be rigorous performance evaluation of the judges, because judges are appointing themselves, they are also evaluating their own performance. Take the case of collegium system. 4 senior judges of the Supreme Court, along with the Chief Justice, will evaluate the performance of hundreds of judges in our country. Is it possible? And how do they evaluate? What is the parameter? People have the right to know, because accountability should be there. And efficiency. How they are promoting those judges? Judges are promoted from the High Court to the Supreme Court. How? What is the process? People have the right to know. Transparency, accountability, participation, consensus, rule of law. Combined together, we call it as good governance. And we need that kind of good governance in the functioning of our judiciary. I am sure this is a very good opportunity for the people to discuss about the performance of judiciary and come out with some long-lasting solutions, rather than thinking about any short-term, ad hoc solutions like this in-house inquiry committee. We need some long-lasting solution. We need the people of the country to come together. For example, there should be social audit of the performance of judiciary. Let the lawyers, civil society organizations, media, NGO, other stakeholders come together and evaluate the performance of the judges. And that performance should be made public to everyone. And that performance should be the criteria for them to be promoted to higher level in the judiciary. And that is where we can find long-lasting solutions. Because,
Definitely.
Because as I mentioned, 3 things: efficiency, accountability, and performance. These things are very important.
Definitely, this is going to be very breakthrough reforms what you discussed. And again, thank you everyone again for joining the discussion today. Thank you viewers for joining us today. One thing what we got today to know was there has to be a very fine balance which needs to be maintained between judicial accountability as well as its independence. So viewers, please pin down your comments. How do you propose that this balance has to be maintained? So until next time, all the very best.